today with David P. Rowe, Professor of Law at the University of Miami School of Law, looking out towards the Caribbean Sea, Fort Lauderdale, Florida. Good afternoon, Professor Rowe.
Good afternoon, sir.
Could you please speak about the recent developments in the Buju Banton case concerning his bond?
Well, Buju Banton has received a very restrictive bond from Magistrate Port Kelly. He must post a $250,000 corporate surety. He must remain under the supervision of a security team of private police officers who will see to it that he stays in home detention in Tamarack. He must remain in home detention except for when he will go to the doctor, go to his lawyer, or go to church. The home detention security team must be approved by the judge or must be submitted for approval by the United States magistrate. He must also give up his passport and waive his extradition. This is quite a restrictive bond, and when you add to it that he is subject to pretrial services random drug testing, it is thought to be quite a challenging set of conditions that Mr. Buju Banton must comply with prior to his trial in December. He will benefit from this bond if he is able to get an immigration bond from the Department of Homeland Security.
What would be the implications of that?
Well, if you were to get a bond from the Department of Homeland Security, then he could take advantage of the criminal law pretrial detention bond that Agent Port Kelly, that United States Magistrate Port Kelly, has granted to him.
What is your current view about the potential new trial, and what effect will this bond have on the trial, do you think?
Well, the bond ought not to have any impact on the trial, but the new trial may be affected by the fact that the two co-defendants will have been sentenced by the judge prior to the commencement of that trial, and those co-defendants may be witnesses for the United States, witnesses for the prosecution, therefore.
In what other ways will the government change their strategy?
It is difficult to say, but the government has had a chance to see Buju Banton's entrapment strategy and entrapment tactics, and they may have how shall we call it, a surprise or two for the defense, particularly since the government is in a situation where they are able to obtain a superseded indictment. In one of the notes that was made to the clerk in open court, the prosecutor indicated that he would supersede the indictment. So it is quite possible that the indictment that Buju Banton went to trial on the first time may not be the indictment that he'll go to trial on the second time.
Professor Rowe, thank you very much for your time.
Thank you, sir.